Hello everyone. So we've wrapped up a number of segments on contract law, and now we're going to move into something called product liability or torts or negligence, and this is a very large area of the law that is completely different and apart from the normal contractual breaches that we've been looking at the last several weeks. A tort is essentially, at its most basic, something you do or fail to do that hurts someone else. And so you are if you watch the news, you're familiar with a lot of events that happen that fall in this really big category. Someone slips on a wet floor in a store and hurts themselves. The famous case a number of years ago where a woman got third-degree burns when she spilled hot McDonald's coffee in her lap. These all come under this general umbrella of torts and negligence and product liability. And what we're going to try and do in this video is take all of these, hey, I've been injured, what are my options here? Scenarios, and break them down into very specific categories of actions and what's required in each. So as a general rule, we will touch on things like, a slip and fall in a store, if you've got a small store. But I'm going to emphasize product liability for this particular video. And product liability, that's what it sounds like, is when you become liable for damage that your product that you've made does to someone else. And when we talk about product liability, everyone in the chain, meaning the manufacturer of the good, the wholesaler, the distributor, the retailer, can be held liable because they're all part of that chain. So you may just be a retailer. You may have a small mom and pop store, but you're selling things that were created by some large corporation somewhere else around the world. It is possible. You have the potentiality of being held liable for the goods you're selling. It's important to understand all of these different causes of action that are possible. When we speak of product liability, the law draws from three different branches of the legal system to determine if you're liable or not. The first is common law. We've talked about this in every lesson. What have courts said? What have they said is or is not negligent? What have they said someone is liable for? The second, and we've touched on this already, are provisions of the Uniform Commercial Code that may impact liability. And the third are specific statutes that different states have that are unique to those particular states. When we looked at contract law, we saw that the only damages you are entitled to receive for a breach of a contract is essentially where you would be had the contract not been breached. When we speak about torts and product liability, there is a whole world of possible damages that are open to you if you are the plaintiff. You can win damages for medical bills, for lost wages, for lost future wages. Maybe you're a concert pianist and you've lost a finger due to a malfunctioning product. You can sue and claim for future wages that you will no longer be able to collect. Pain and suffering, property damages, and in narrow cases, if the defendant, if the producer of the good was particularly reckless, you can get punitive damages, which basically means in addition to all the damages that you're entitled to, the court is going to punish that producer for their bad behavior and give you an award on top of that. So this is a much broader series of remedies that are available to you if you are suing in tort or negligence or product liability. On the other hand, if you are the business owner who's being sued, your liability is also much wider as well, on the other hand. So when we look at this, let's start dividing this down. There are three different levels of responsibility or liability that courts will look at. The first is intentional. When you intentionally do something that is reckless, that is likely to cause harm to someone, and you know it, and you do it anyway, this is an area of the law where you are likely to get hit with punitive damages on top of everything else. Depending on what you did, there may even be criminal liability. So there's intentional acts or failures to act. The second approach is basic negligence. When we talk about negligence, we're basically saying that you acted in a way that was unreasonably unsafe. It's not that you necessarily went out and intentionally hurt someone or intentionally lied, but what you did was unreasonably unsafe. So to give you, or you engaged in a risky behavior and you should have known that this could have hurt someone. And this is why these kind of issues go to a jury to decide, because you've got a jury of average men and women who are deciding, was the action reasonable? If you own a store and someone maybe coming in broke the doorknob and now it's sharp, and you do nothing to fix it or put a sign up or open the door or warn people about it, it is likely, now what you did was not intentional, you didn't break the doorknob, but it's likely that a jury will find that that was unreasonably unsafe. You were aware of the fact that you had a dangerous situation on the doorknob on your store. You were aware it was sharp. You were aware it could hurt someone. And you took no action to remedy that. That's a really good example of acting negligently, because it's simply unreasonable. And what's reasonable and what's unreasonable is what the average person perceives as reasonable or unreasonable. So you've got intentional acts that hurt people. You've got negligence. You didn't mean to hurt someone, but you were unreasonable in how you approached the situation. The third category is what we call strict liability. And with products especially, strict liability means it doesn't matter what your intentions were. It doesn't matter if you were negligent. We don't have to show that you were unreasonable. If your product caused the harm, you're strictly liable. So we've got these three different categories based on your actions: the intentional, the unreasonable, and I did nothing wrong, but my product hurt somebody. Now, when someone, and I'm going to assume for the rest of this video that you are the store owner, you're the little guy, you're getting sued by someone. They can choose 5 different legal theories as to why you should be liable. And they don't have to just choose one. They can choose a combination of the 5, depending on what their lawyer obviously believes is going to be the best case for them. So let's go through these 5 causes of action. The first is a design defect. And that means the product, as it was originally designed, as it was created, was unreasonably dangerous. Now, there are some products that by their very nature are dangerous. A chainsaw, a firearm. That doesn't mean that someone who gets injured by a chainsaw or by a firearm has an action because that's not a design defect. However, a design defect could be that the chain on the chainsaw was designed in such a way that it was very fragile and snapped and hurt you. Or it could be on the firearm that the design of the safety that keeps it from going off accidentally was poorly designed, and the latch on the firearm doesn't stay put and it falls, or just walking with it, the vibrations make it come off. That would be a design defect. In order to prevail in a case where a design defect is the issue, you must show negligence. Okay? You must show that they knew, or they should have known, this was going to be an issue. If the manufacturer or the designer had no idea that this could be an issue, and it wasn't reasonable to anticipate this particular problem, then it most likely will not prevail as a design defect. The plaintiff also has to show that they used the product in the manner it was supposed to be used. So I can remember a case way back when I was in law school where someone got out of the shower, a young woman got out of the shower, and she needed to dry her hair really fast, and she had left her hair blower somewhere. So she used a hot air popcorn popper to try and dry her hair. And her hair got caught up in it, in the mechanism, and pulled it out. And she actually sued in product liability as a design defect. The court did not accept that because that was not using the product in the manner in which it was intended. It wasn't reasonable. The popcorn manufacturer was not negligent by not anticipating that people would be drying their hair in a popcorn popper. Excuse me. So that's your first avenue of approach, a design defect. The way it's made, they should have known there'd be a problem. There were cases in the past where cribs were made with the slats much too wide on the crib so that babies could either fall out or get their head stuck. That would be a design defect, because you would have thought that someone designing a crib would have taken some measurements on the size of babies' heads and figured out what would be the best distance between the different slats on the crib. So you show negligence and you show that you used it as it was intended. The second is a manufacturing defect, and that is different from a design defect. The design defect is, this is how we made it. This is how we intended to make it. A manufacturing defect is that something went wrong on the production line. They're making some type of product that has metal parts, and they screwed up the combination of different metal alloys so it became brittle. Something went wrong on the assembly line. It was not manufactured according to its original design, but they screwed up along the way. If you are able to show that it is a manufacturing defect rather than a design defect, you do not need to prove negligence. Manufacturing defects have strict liability. Once the manufacturer does something that is their own fault, their own mistake, their own error, some problem on their assembly line, they are automatically strictly liable for the damage the products cause, and no one's got to show that they were negligent. So they can say, we did everything right, we followed all the rules that we were given, and we didn't do anything wrong. Doesn't matter. It's a manufacturing defect. You are strictly liable. The third is called by some states a marketing defect, and by other states it's called a failure to warn. In these cases, it was designed correctly, it was manufactured correctly, and it's not necessarily unreasonably safe. However, for some people, it may contain some dangers. So, for example, if a cereal company uses peanuts in their, maybe it's a granola mix or something like that, peanuts are not unsafe. They are not unreasonably unsafe. However, for people with peanut allergies, it can be fatal. So the law requires that if you are doing something that's not really unreasonably unsafe, but it could hurt someone, then you need to warn them. You need to let them know that there is the potential of a problem. Now, this can be carried to an extreme. A Bic lighter does not need a warning saying this produces a flame that could set things on fire. That's the purpose of it. But if you've ever gone crazy watching prescription commercials on TV, where they tell you, 10 seconds about what this could do for you, and then say, side effects could be, and people who have this condition should not take it, consult you. This is why. A failure to warn, if that's the case you're making, you didn't warn me about this, you do need to show negligence. You need to show that the company was unreasonable. So if they didn't know that this could be a danger to someone, then they're probably not going to be found liable. They designed it correctly, they manufactured it correctly, it's not unreasonably safe. We found out something later on down the road that could hurt someone. Once they are on notice of that, then it is likely that a jury will find that they've acted unreasonably, because it's been brought to their attention that there's a potential issue, and they failed to act on it, and they failed to warn people about it. The fourth cause of action someone may have against you is a breach of an express warranty. An express warranty is a claim that the company expressly makes. So a good example of that would be a case involving Ledra-Plastic. Ledra-Plastic is one of the companies that manufactures those big round plastic-like balls that you may see at a gym. And they expressly marketed this, saying that these balls could withstand a weight of up to 600 pounds. Well, a player in the NBA was sitting on one of them doing chest presses with dumbbells in a gym, and it exploded underneath him, fell down, broke an arm, had lost wages in the future, and he sued Ledra-Plastic. In the courtroom, they actually took one of these Ledra-Plastic balls and exposed it to weight, and at 400 pounds it collapsed, not 600. So this was an express warranty the company made that it would hold 600 pounds. When a company violates an express warranty, it is strictly liable. It doesn't matter whether they were reasonable. It didn't matter whether their research showed it would hold 600. It didn't matter whether they tested it 100 times, and it held 600 pounds. If you make an express warranty that your product will do something, and it doesn't, and injury occurs as a result, you are strictly liable for what has happened. So, lesson there. If you're marketing something, make sure your marketers speak with your legal department. Because if you make a claim for something, you better be able to carry through on it. Your product better be able to carry through on it, because otherwise you're strictly liable. The fifth cause of action that someone could have against you is one we've actually already referenced, because it's part of the Uniform Commercial Code. And these are, and it's really two, a breach of an implied warranty of merchantability, an implied warranty for fitness for a particular purpose. In both of these cases, it's actually strict liability once again. We expect that a lawnmower is going to cut grass. We expect that if you say that something can be used for a particular purpose, or you know what your end user is using it for, and you say, hey, yeah, this will work, it better work. Both of those are strict liability issues. So, something happens, and your product causes damage to someone. They can sue at any of these levels. And the differences of these levels are really critical because your burden of proof is so different in all of them. And because this is tort, because this is negligence, you don't need privity of contract. Meaning, if I've got a contract with someone, or I buy something from someone, and that product hurts someone else, they are able to sue. It's not a contractual, a private law issue. This is now a whole different area of the law. So, you can sue based on a defect in the design, a design defect, but you must show they were negligent, it was unreasonable in how it was designed, and that you used the product as it was intended. If you're using a lawnmower to ride over a pile of trash that you've got in your backyard because you want to mulch it down, and you get hurt when glass flies out and hits you, you're not going to prevail. You're not using it as it was intended. 2, you can sue as under the manufacturing defect proponent. If you claim that there was a manufacturing defect, it could be harder because you've got to get information from what went on in the company to see if there was something actually wrong with the manufacturing process, but you don't need to prove negligence. There is strict liability. If they screwed up in the manufacturing process, they are liable. 3, failure to warn or a marketing defect. If your product is generally safe and you've made it safely, and but you know it could be dangerous in certain situations, it could harm certain people, you have a duty to warn them as to what could happen. You do need to show negligence on that particular action. So if the company has been warned this is an issue, if they've been sued before because this is an issue, now they're on notice, and it's unreasonable if they don't take that action. If you want to know why cigarette packages have all those warnings on it, that's a direct result of an action against Philip Morris, specifically under this legal theory, the failure to warn of potential danger. 4, the company says this product will do something and it doesn't, and you're harmed. You get a breach of express warranty, strict liability, you don't need to show they're negligent. And 5, if there's a breach of an implied warranty for merchantability or fitness for a particular purpose, then once again it's strict liability, and you sue under the Uniform Commercial Code. So those are 5 different ways someone can sue a manufacturer. Now, in most product liability cases, you're talking about little guys versus big guys, Davids versus Goliaths type of situation. And that's why almost all of them, when they are brought as class actions. The action against Johnson & Johnson for asbestos that was in talcum powder, and they knew asbestos was dangerous and continued to use it in the talcum powder for 10 years, was a class action lawsuit. Lawsuits against Monsanto for cancer-causing agents in the weed killer Roundup, class action lawsuit. There was another company, a pharmaceutical company, DuPuis, that made hip replacements, and it was metal on metal. In other words, your movable part was metal, and it was in a metal socket. And over time, as people walked, the metal grinding against the metal created small pieces of metal shards that went into their body and caused all sorts of other issues. Class action lawsuit, and those coming against Dupuy prevailed because they showed that it was a design defect. They showed there was a failure to warn. They sued under both provisions, and they showed that a reasonable company designing metal parts moving one against another for use inside your body, they should have known or should have looked at this, and that was negligent and unreasonable. So it's a very complex area of the law, and there's many different angles to approach a lawsuit if you're damaged. For you as a business owner, selling products every single day from 200 different manufacturers, it becomes important to stay on top of the news in terms of, is there a recall? Did someone complain about this particular product? If they complained about it to you, maybe the manufacturer doesn't know about the issue with the product, but now you know about the issue of the product, and if you continue to sell it, knowing there could be a defect without warning your customers, the producer may get off the hook even though they created a defective product. You will not, because you have been put on notice, and it would be unreasonable for you, and it was an unnecessary risk to continue selling a product that your customers have reported to you is dangerous. Anyone in the entire supply chain can be sued, and who is negligent is all based on, well, what's reasonable given the knowledge you have. So we're going to look at a particular very short fact pattern today in our lesson for your writing assignment, and I look forward to your responses to it.